Oh, there you go. Welcome back, everyone, to another episode of Business Talks. I am your host, Chawanne Burns. In today's video, we're going to discuss the YSL trial. Brian Steele, he's the attorney of Young Thug, and he was held in contempt of court. He was sentenced to jail for 20 days in jail on the weekends. Okay, and it is unreal why the judge held him in contempt of court. Everyone's saying, or I guess the streets are talking, that this judge may be corrupt because of they had some type of behind closed door conversation with one of the witnesses that was sworn in that was actively giving the testimony. And Brian still called him out on it. And so the judge was mad that he ended up finding out about this conversation that he wasn't supposed to know about. And so he held him in contempt. Okay, so we'll talk about that and much, much more. We're going to talk about a little bit of in Chicago, this going on with Brandon Johnson. And you guys stay tuned.
Something like this. Looks a little bit like I can't miss. Hey, this is what you call a bad. What? This is what you call a bad. Looks a little something like this. Looks a little bit like I can't miss. Hey, this is what you call a bad. What? This is what you call a bad.
That's right. You guys put in the chat. Let me know where you're viewing from. Put in the chat. Let me know where you're viewing from. I see we have Noble Young in the building. It's always good to see you. Brian Britton, what is good, from South Carolina. Kennard the DJ, listening as always. It's always good to see everyone. And, thank you for tuning in. Brian C is tuning in from St. Louis, and Kennard, of course, Chicago, right? We're gonna get into it. Okay, so the judge for this YSL case, I don't know what is going on in Atlanta. This is Atlanta, you guys. What is going on in Atlanta, where we have so much corruption in Atlanta? We just talked about the ex-police officer and attorney that was convicted for 7.5 years for stealing $15 million of PPP loan. And she was already awarded, or recently awarded, the largest sewer contract in Atlanta of $99 million. So you're able to get contracts and probably was hooked up with that. And you still want to be greedy. You want to steal $15 million from the national government, from those businesses that are actually struggling. You're taking money from them. So anyway, she was convicted. And then you have Fonnie Willis. We know about Fonnie Willis. And Adrian Love is one of the other attorneys. She's the prosecutor attorney on this YSL YSL case. Okay, so they're charging them with the RICO charge, and it to me is very shameful, because we have a bunch of Black leadership that is struggling to steer people. Your integrity is compromised, and you're of course you're in the media, and everyone is holding their faith to you, because you're supposed to be prosecuting Donald Trump and all this other stuff and getting rid of crime, all the while that you're doing criminal deeds. So the faith, the public faith or public trust, is really low in the city of Atlanta, really low. And I don't understand how a person can actually live in Atlanta and say, oh, this is a great city to live in, especially if you're into politics and you're into this type of space. But I guess if you scratch my back, I'll scratch yours. I'm assuming that's how it works in Atlanta. And I think that's how it works everywhere, but more so in Atlanta, because that's how the game is. Okay, so I'm just gonna play. Let me give you a preface to this. This happened on June the 10th. Okay, Monday. They were supposed to start court at 8:30 or 9 o'clock. They didn't start till 11 o'clock. And unbeknownst to the defendant attorneys, they were having this closed door meeting. They called it an ex parte meeting. I'm not a lawyer. I'm not a trained lawyer. This is what I read over the internet. If you guys want legal advice, maybe you want to visit somebody else. But from what I read of this ex parte communication, they're able to have this type of communication, but all parties are supposed to be aware of the communication, and it's not supposed to be anything that influences the case. Okay. And it's supposed to be transcript or transcribed of whatever type of form of communication they had with the prosecutor, the judge, and whatever. And so basically scheduling matters. That's literally the only time you're supposed to communicate with the witness, because the scheduling matters. It shouldn't be anything else to do with the case. And Brian Steele was he was privy to this information. The judge got mad because he called him out. So this is where Brian Steele at 11:30, they started actually late. And at 11:30, Brian Steele became aware of this information. Somebody told him. And the judge got pissed off at him. So this is where they start the conversation. Let me just speed it up. You guys, let me know if you could hear it. Put it in the chat.
Yes, he's right behind you.
Okay. Okay. Let me just slow it down now.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland. All right, you can make it right now. Is he out? Let me know when you get down. Is Mr. Copeland out? No, he's upstairs. Okay, good. All right. Yeah, come on down. Don't come in the court. Come and get you back. Thank you. Go ahead. The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, he did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never. Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that? Well, I'm disturbed too. And the reason I'm asking you a question. How did you find out about it? I'm going to ask you the question. Okay. Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage. It's just like when you meet with me,
and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going
did
to
you?
answer that question.
You're not.
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make sure that what I say is accurate. I'm not trying to.
No.
anybody else
I'm
to
asking
say
you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information. Then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was.
I don't want to be held in contempt. Well, I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
So the camera goes off and they cut the feed. This Judge Ulo, you guys, Judge Ulo, Judge Glanfield, I think his first name is Ural Glanfield. What kind of name is that? But anyway, he's pissed off that Brian Steele has this information. He's pissed off that he got caught red-handed. He's pissed off that Adrian Love, let's go back to Adrian Love. You see her every time he was talking. This is Brian Steele talking, and she is saying, she's going like this. Me? Oh no, I never. Both of them are intimidating the witness or coercing the witness. Hey, if you don't say what you're supposed to be saying, we gonna hold you until we can no longer hold you. This is the guy that they had the meeting with. This Kenneth Copeland guy. He's also known as Little Chico. No, Little. You guys forgive me. Little Woody. His name is Little Woody. Okay. This is the guy right here that they had this meeting with.
Before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right
I don't
now.
want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for? This, what
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you?
This happened on June 11th. Okay. The day after they found out they was meeting with this guy. Okay. Why did he go in the next day and say, oh, I'm going to fire her? Does that make any sense? So he probably the smart one out of the bunch. He probably is thinking, hey, I'm in a spot, a rock in a hard place, and I'm not going to get out of this. Anyway, this is the guy. This is the guy that they had a meeting with. And some of his I want to show you this one testimony. Let's see, where is it at? Let me just go to my bookmarks. Why didn't I say that? Okay, this is it. This is it.
With me. You asking me all type of relevant questions that ain't got nothing to do with me.
He's kind of big and light skinned.
What do this got to do with me? You asking me all type of relevant questions that ain't got nothing to do with me. I ain't shooting nobody. I ain't rock nobody, man. You feel me? This ain't got nothing to do with me. I shouldn't be here.
This wife, you recall?
I shouldn't be here. I shouldn't be here. I shouldn't be here.
You recall?
I shouldn't be here. I shouldn't be here. I shouldn't be here.
You recall the
I
text?
shouldn't be here. I shouldn't be here. I shouldn't be here.
Do you recall the text?
I'm ready to go back to
When you
prison.
say big, like tall?
I'm ready to go back to prison.
Do you recall? He's kind of big.
So, and everybody know the street code. They ain't gonna snitch on each other. This, they're trying to force, somebody to testify, and it's not working out in their favor. They rather do the time. And that's the street code. I mean, they prefer to die with the truth and then to snitch on somebody else. But the judge and Adrian Love and everybody knows you shouldn't have, if you guys ever get in trouble, do not use a court appointed attorney. Try to scramble up the money that you can, because most of the time these court appointed attorneys, even maybe even attorneys that you pay for, they are in cahoots with each other. They're not really looking out for you. They're looking out for self. They go behind their little boardroom meeting and say, hey, this is the deal that we want you to accept. It sounds like a good and solid deal, instead of really fighting for your rights or your freedom. They don't do it. They cahoots with each other, and they collaborate with each other, and ultimately is on the cost of you, whether you did the crime or not. You're going to pay the cost. Anywho, so this is why they're trying to, or the judge is really mad, because they wanted this guy to testify. They didn't want him to plead the fifth. They didn't. They did not want him to plead the fifth. They want him to say what he knows about Young Thug or whatever questions, and not plead the fifth or whatever. And they threatened him. And Brian Steele found this out. And then the judge got mad because he found it out. And he's really upset because Brian Steele won't write out his sources. So he didn't deny it, though. The judge, Glanville, did not deny that he met with these individuals, and the conversation was that. And he even says, "You're repeating to me a verbatim conversation. I want to know, where'd you get this from?" Now we're going to go back. Let me just, they're in recess. He said he's going to come back in 5 minutes. It actually took him about 15 minutes to show back up.
All right, do we have everybody with you? Sergeant Ingram?
Yes, sir. Everybody's present.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be.
And that's not fair, Judge. He shouldn't be able. He shouldn't have to share to you where he got the information from, because he's not trying to rat out his sources. That would be a horrible attorney if he told you where he got the information from. The guy that gave him the information, guy or girl that gave him the information, they're not on trial.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't happen.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte?
Like
it's ex parte under
It's
seal.
ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot. You can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you.
The privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an
may be
idea how
wrong.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not
Sir,
going to
I don't want to hold you in contempt, but this is that serious.
Judge,
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen, and listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay,
talk
well,
about
then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well, then, other than
Answer
if
that.
you were
I'm the
sitting,
attorney
unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that was a privileged communication. It shouldn't have
Well,
been.
it's because she has a client she's supposed to represent.
Who are you talking
But anyways, I'm not going to have a,
When I got
I'm
this
not gonna have any
information-
further- I'm not going to have any further conversation
Well-
with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside of presence. That's really it.
You can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your
Court-
I'm going to deny
I
your
mean,
motion. I'm going to deny your motion.
I
for
understand that you
mistrial.
spoke with the
And when-
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is
you-
appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay?
Why
That's for
did we
another
exclude
day.
in the first place? I didn't know about this.
That's for another day.
How's that for another day? And you trying to convict Young Thug for what, 30 years? He possibly get 30 years for the crimes that you trying to charge him for. He's literally on trial. Brian Steele is doing his job. He's doing an excellent job. The judge, he's a piece of shit. You're trying to overstep rule, put this, hey, I'm the judge and it goes whatever I say, this goes. No, you still have to follow the rule of law. You can't just do whatever because you're the judge. And so they're gonna hold him in contempt. Okay, they're gonna put him behind bars. And his co-attorney said, hey, I'm not gonna represent, I'm here to represent my client, but I don't feel comfortable with my co-attorney, my partner behind bars, and I still have this full trial. My client hired both of us as a team. He didn't hire one person. He hired both of us. So you could potentially be a mistrial because of that, because I don't have proper representation. So they're going to go on and go back and forth about this.
So I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read the case, I'm assuming you read it. That's what it says, and you did it.
The state wish to be heard.
You said it supposedly. Yes, John. And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it, and then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
You can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there. Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
Why aren't we?
that needs to be told. But
right now, we don't know why we were excluded from that.
Mr. Steele,
and I want that information because
Just
Mr.
stop.
Williams' constitutional right under
Just
Georgia
stop.
Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
We're not waiving anything.
Yes, madam.
So Adrian Love, she is saying, "Oh, I don't want him to miss the trial. Is there any way that you could hold him a contempt of court on the weekends? So he had to serve his 20 days or whatever on the weekends. But I believe he should be in a courtroom to hear what's going on and not secondhand knowledge. The problem is, you see, Brian still asks for these transcripts. Okay, if you're telling me that this is on a conversation, up and up ex parte conversation, and they're allowed to get ex parte conversation transcripts, okay, where's the transcript? Oh, you'll get that after court. You'll get that through the appeal. If this court case goes through appeal, you'll get that. They weren't even trying to give them the transcripts because the judge knows he is wrong. He is flat out wrong. Now, so a lot of attorneys showed up for Brian Steele the very next day. A lot of attorneys. And so Brian Steele, now you guys might not know this lady in the pink. She is one of the attorneys for the co-defendants for the Donald Trump trial. Her name is Ashley Merchant. Ashley Merchant is Brian Steele. Well, she's acting as Brian Steele's attorney. And Ashley Merchant asked Judge Glanfield to recuse himself from attorney Brian Steele's contempt charge case. Glanville wants to jail Steele unless he reveals the name. That's Glanville, you can't I'm going to jail you until you reveal the name. That's some bullshit. That's some bullshit. Merchant states judge is witness to whatever ex parte communication occurred in his chambers. So now you're acting as a witness. And this is what they did in Donald Trump's trial. And not to the judge. They had
identification of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you aren't part of them, by nature.
Okay, well.
You have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe that somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had.
No, Judge, he did not call. Don't try to blame Brian Steele for having insider information. Hey, we are scheduling the meeting at 8:30 between the prosecutor, Copeland's attorney, or I think the guy's name is Copeland, attorney, and the witness and the judge. We don't need you to be there. This is some type of scheduling, blah, blah, blah. You shouldn't be talking about the case. You shouldn't be talking about, oh, what's the problem? Why can't you answer the questions? No, that's not what you're supposed to be talking about it in this quote unquote ex parte communication. That's why a court reporter is supposed to transcribe that and make it readily available for the defense team or whatever parties was missing. So you can't just say, oh, Brian caused that. He caused that because he knows the information. No, he should have been alerted. When the meeting was scheduled, you guys should have told him.
To begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold him in contempt. So, at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. We would ask for you to be recused from this case because you are a witness necessarily. It cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. And he has the right to subpoena witnesses. He has the right to an attorney. He has the right to due process, notice, a show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let an appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
Okay.
And we need to have the order reduced in writing as well.
I'm going to do that right now. I will state for the record at this point in time that Mr. Steele has in fact or has filed, and I will note this as part for the record in this case. He's filed a motion to set aside the contempt. He's filed a motion for a supersedious bond, and he's filed a notice of appeal, all of which I will include as the next court's exhibit in order.
but I'm reducing the contempt to writing. And I mentioned earlier, he can purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, criminal contempt, he's got to be sentenced.
Well, his contempt is, as long as he, when he tells me what the basis of the conversation was, who, I didn't ask what, but he tells me that, then I can certainly, he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt,
That's civil.
Judge, and that's respectfully, I would point you to In Re Hughes, which stands at the same point of law. Civil contempt impose punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and a $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge, which is why the enhanced due process protections apply to that. Now, Mr. Steele has indicated to us he does not believe that he can answer the question without violating his duty of loyalty and duty of confidentiality to his client. So he is being placed in a position where he's either going to jail or he's going to commit an offense that will put his license to practice law at risk. And that is an untenable position to be in. And Mr. Steele is a zealous advocate for his client, and he is simply trying to protect that duty of loyalty and duty of confidentiality, because if he answers your question, it is very reasonable to assume and likely that he will be facing a bar complaint that could result in a suspension or in
disbarment
of his license. And so he's in a very, very difficult position where if we were able to have a full contested hearing with the benefit of witnesses and an impartial judge where you're a witness, then everybody could present their side of the story. And
I'm not doing that. The reason being is because that takes away the whole point of criminal contempt, and that is you do something, the court tells you to do something, order of the court, and you don't follow it. I didn't ask him to do anything illegal, immoral, unethical. I just asked him to tell me. I know what the...
It is unethical, though. It's unethical because he said, I'm protecting my client. I can't reveal my sources because my client is the number one person that I protect. So it's unethical. It's unethical because I could lose my license. What are you talking about? Or I could get suspended from the bar. So what is he saying? I think this judge, he wants it his way or no way. That's what it sounds like. And I think Ashley Merchant, I believe that's her husband, they make a good argument of whether this contempt is criminal or civil. And it sounds like it's more civil than anything because you're saying it's either or. If you tell me we will relieve you of that contempt of court and you will no longer have to serve jail time. But I'm an attorney, so I'm going to protect my client. Okay, so a lot of people showed up, attorneys showed up. I see somebody in the comments saying, yeah, there was over 40 attorneys that showed up. Lexi says, many of the witnesses in this case has been very difficult to say the least. Yeah, Lexi, the street code, these are gangbangers. Gangbangers, they probably rob, kill, steal, sell drugs, do whatever. And they rapping about the dirty deeds that they're doing in the street. But the street code, you're not supposed to snitch on each other. So if they rob, kill, and steal, they take that to the grave. They're not going to snitch on a person. And if they do snitch on the person, or whatever, on each other, they could possibly be in danger themselves. Kennard, the DJ, said he and Tiffany he and Tiff went to the same college. Where did he get his law degree from? You remember those Cracker Jacks, you guys? Was it called Cracker Jacks? The caramel corn with the peanuts? You always get a prize at the end. It was like some hologram. That's where he got his law degree from. Dwayne said, I don't think the judge is crooked. I think he got mad and made a career-ending mistake. I guess that's one way to put it. Yeah, a career-ending mistake. And maybe he's not abreast about that part of ex parte communications. I'm not for sure. How long has he been a judge? Let's see if it comes up. Judge Glanfield. He's been a judge for quite some time in Superior Court. Magistrate Court 1995 to 2004, Chief Judge 2022, 2005 Superior Court of Fulton County. He went to University of Georgia. That's where he got his Juris Doctorates from. And he actually was a professor, adjunct, a professor of the University of Georgia Law School. And a lot of times when you argue, have these oral arguments and you go back and forth, a lot of times it's your perceived belief of what this terminology is saying. And usually they have to reference other court cases. Okay, what was the findings and the ruling in these other previous court cases that had this same dilemma? So I believe the appellate judge will probably rule in his favor. They did file an appeal about this whole contempt of court case. They filed an appeal. And it says Brian Steele's wife filed the appeal. And it says, notice to hereby that the Brian Steele hereby appeals to the Court of Appeals of Georgia from the order of contempt on June 10th, holding Brian Steele in criminal contempt. And the clerk was kindly take note that the transcript of evidence of the proceeding on June the 10th are to be included with the record of on appeals. No other portions of the record is to be included for this appeal. And the Court of Appeals of Georgia has jurisdiction of this case on appeals. This day, 10th day of June 2024. So you're trying to prosecute a RICO charge, and I'm not saying Young Thug is innocent or guilty. It sounds like they've done some pretty bad stuff. So you're trying to get criminals off the street, but you might lose this court case because you have uncorroborating witnesses, and also you're trying to strong arm people into saying what they shouldn't be saying or what they don't want to say. You're trying to strong arm people because this court case is a national court case and you have to win this. Remember, Fonnie Willis said she has an impeccable record of prosecuting cases and winning them. Well, if she lose this one and the Donald Trump one, remember Donald Trump is his trial is on hold. That's going to be a big stain in her career. And people are very irritated in Atlanta with I guess the crime levels in some areas. And so you and the judge and your second in command prosecutor, Adrian Love, you guys kind of shambled this one up. You really messed this one up. And I could see that they will they probably will do a mistrial, even though all the co-defendants and even Brian Steele demanded a mistrial, and this guy Glanville, Judge Glanville, he denied every single last one of them. He didn't even want to hear it because he thinks, hey, I'm right and you're wrong. I can have ex parte communications and you're wrong on what you're trying to, I guess, prove. He didn't even want to hear arguments for that. Anyway, you guys let me know what you think about that. Lady Diva Love, good afternoon. Grand afternoon. Preacher Man 101, I believe that whoever told, like Steele said, had the constitutional duty to report it because Love and the judge are going down for this, and the person who told is covering their butts. Yes. Fanny screw up. A RICO case with so many defendants is a joke. Yeah, I think the reason why I think they're totally screwed up. People are sleeping with each other. I remember, you guys go back to some of my old videos about Fannie Willis. Fannie Willis ran on, hey, my office will be very up and up, straight. We won't have these love affairs, corruption. You won't have to worry about that coming out of our office. And if someone says they're trying to come at me that way, I will have to let them go. If I hear of something like that, I would have to let them go. But that seems not to be true in Fannie Willis. It seems like they're sleeping around with each other. They're padding each other pocket. It's corruption within the district attorney's office. And it goes all the way up to the Superior Court judge. You see, even Judge McAfee, he was scared to even make a ruling because, quote unquote, he was up for re-election. Even though he had some strong words for Fannie Willis and Nathan Wade, he basically said, I know they lied, and their relationship with each other was questionable and need a further look into, but he still didn't make a decision. So Fannie Willis in that district DA or Fulton County, they got some work to do. They need to clean house again. But I believe Fannie Willis, she'll be reelected again. I believe so. They really like her down there. So I believe she's not going anywhere. This judge, he probably won't go anywhere either. You know, he's been in there so long. People elect off for name recognition. They know the name, so they're going to reelect them. Anyway. I just want to make sure. Lady D will love for Kales, but no snitching. Yeah, you can't snitch. That's just like the code. That's why they had to strong arm some of these witnesses. Anywho, we're gonna get to Chicago before I head off. The kids are out for the summer, so I really gotta stay on my strict 1 hour talk time. So we're going to get to Chicago, and reason why I want to talk about Chicago because it was brought to my attention a few days ago. Tiffany Henyard was exposed, quote unquote, for the same thing. I don't know if we call that and exposure, but I can say that they brought it to light. And what I'm saying is Tiffany Henyard, she was caught billing the township for her makeup services. You know, they had this guy on payroll, and the guy came back. I think his name is Brian Mormon. He was acting as an administrator at some point in time, and then he kind of rolled over into Tiffany stylist. I would say, you know, okay, he's an administrator, and if they continue, now these were old receipts that they pulled up. If they continue to see him being on the payroll, okay, then that would be something to look at. But is he actually acting as a stylist, or is he actually acting as an administrator? No, nobody knows. This was back in 2023, mid 2023. But it was some like $1,500 billing statements. But your boy Brandon Johnson doesn't have any hair on his head. You know, Brandon Johnson has a really kiddish, I guess you want to call it, pointy thing on his head. And let me just share this. This is Brandon Johnson's hair. He paid $30,000 for hair and makeup. Like, what in the world? $30,000 for hair and makeup over the past year. What in the world are you talking about, Brandon? And this, he's coming, they said he's taking it out of his campaign fund. So they're saying, oh, this might be, you know, illegal campaign. You know what they got for Trump. Trump, you paid $150,000 to Stormy Daniels out of your campaign fund. Let's see if they prosecute Brandon Johnson over this illegal use of money of your campaign funds. And it probably won't happen, but this is Brandon Johnson uses spends $30,000.
We start here at 5 o'clock with questions about Mayor Brandon Johnson using campaign funds to pay for hair and makeup expenses for himself and other people tied to his campaign. The Chicago Sun-Times first reported that Johnson has spent more than $30,000 in 15 months. Election lawyers disagree if it's lawful. NBC5 political reporter Marianne Ahern joining us now with reaction. Marianne?
Allison, election law does not mention specifically hair and makeup. So depending on whom you ask, there is disagreement whether it's legal. He's not the first to use campaign funds this way, but in Johnson's case, he's using those dollars not just for himself, but others too. Last August, when we spoke to Mayor Brandon Johnson in a one-on-one interview, his makeup artist prepped him before we asked questions. Johnson is paying his makeup artist through his campaign donors. Likewise, this hair salon in Austin is also paid with campaign funds. It's just 3 doors from his former county commission office. Johnson has expensed more than $32,000 from January of 2023 through the end of March of this year. Campaign records show the makeup artist was paid $28,000, the hair salon $4,000.
I would be hard-pressed to say grooming is part of your governmental functions. That's not a function of government to look good.
Bert Olson is an attorney who specializes in election law. So does Michael Dorf.
The key is the law does not prohibit expenditures for grooming expenses, and it is absolutely clear that how you look is at least as important as what you say in any political situation.
The Illinois State Board of Elections says, quote, if you're making an appearance as mayor of Chicago and you hire a makeup and hair artist for the event, that would most likely be a legitimate use. But if you're using them for a strictly social event, there might be a stronger grounds for a complaint. You also can't pay more than fair market value for goods and services. During former Mayor Lightfoot's term, she expensed $8,000 total for hair and makeup to
We could tell.
her campaign funds.
If I was to pick a side,
Lori Lightfoot only spent $8,000, and we could tell. We know she got an afro. I think that was reasonable. She has a afro or short haircut, so she probably just get her edges trimmed and the top trimmed off. But Brandon Johnson, what makes it really wild? This is your campaign fund, and you don't spend it on or advertisement or whatever you're supposed to spend it on. You spent it on hair and makeup, $30,000 hair and makeup, and you're a man, and you're getting your people hair done and their makeup done. Like who else is in your life? I guess your campaign manager. You want them to look good, but they should want to look good. That should come out of their little kitty cash. Maybe that's I'm you guys tell me if I'm going in the wrong direction. I'm not for sure. Bert Alderson, you guys know him. He's the Dalton trustee lawyer, and he's saying no, this is something that might be looked into.
I'd pick a side of being on the conservative side, following the letter of the law and not trying to stretch the law.
The campaign money was used not just for Johnson's makeup. In a statement to the Sun-Times, his campaign spokesman says the expenses were for the mayor and individuals associated with the campaign for public appearances, events, media segments, and other availabilities.
It's a political problem for him. It's a public relations problem. I don't think it's a violation of the Illinois Election Code.
We reached out to the mayor's office, who told us contact his county.
But some people are mad about it. Some of his, Brandon Johnson, he has a low approval rating, and of course, some of his residents are mad about it. He was at an event. This was yesterday. And it's saying that exhausted with the city of Chicago ignoring her family issues, Ms. Zoe Lee lets Johnson have it. You are the mayor. They talk about you like a dog. They say you spent $30,000 on your makeup. That's crazy, because Sephora is not even that expensive. Who said he got his makeup from Sephora? I'm not for sure.
That you stated you live on the west side group. 33 weeks I've been coming down to Cook County in the city of Chicago about the city of Chicago knocking down my family's building, thinking that the city of Chicago owned it. You are the mayor. They talk about you like a dog, and like they now saying you spent $30,000 on your makeup. That is crazy if that is even true, because Sephora is not expensive. But the fact that I can't get no help from you is nuts. I hate that I cannot get any help from you. I hate that you are a black man and I can't get no help from you. I hate that you're a black man with 3 kids and a wife that say that you stated you live on the west side, grew up on the west side of Chicago. On the south side of Chicago, they are demolishing our properties and using it, saying that they're using it for affordable housing. It's always affordable housing. They're knocking down seniors' properties and then has vacant lots now. All of a sudden, it's affordable housing. I need help, Mayor Johnson. Help, please, please. Can I get some help? And I apologize, Tony Preckwinkle. I was very upset, but I need some help from my black leaders, please, because David Moore is mine. He's mine. Thank you.
So I believe that was public comments, and that's really odd. The city knocking down a property in thinking it was theirs and it wasn't. But that's going to be another conversation that I'm going to look into. Mayor Brandon Johnson, he's not doing well in the public eye, and this is just going to be the tip of the iceberg, because you can't say, hey, I'm for the people, and when it's exposed and there's like, oh, this dude spent $30,000 on hair and makeup, this is how he living. You spent $30,000 on hair and makeup and you don't even have hair. How many people is on your team that you got to spend $30,000 on hair and makeup? What is going on? What kind of people over a 15 months, say 10 people, that means they're spending $3,000 a year on 10 people. What type of wigs you getting? What type of weaves you getting? Like, come on now. It's just, this doesn't even make any sense. And you know that guys are not spending it. So you probably got, a lot of women staff, and you agreed to say, oh yeah, you put your hair and makeup on my tab. That don't make no sense. It doesn't make any sense. Whether it's lawful or not, it just doesn't make any sense. And really, it doesn't make any sense because you have people in Chicago pissed off because you either closed some of their civil services down. You saying, no, we don't get the money for this and that. No, we can't. We're closing down these shelters. We're because we have to take care of the illegal immigrants. Like, that's why people are pissed off. Now, if everything was on the up and up in Chicago, it would have been some talk, but no, you got a bunch of pissed off people. You're cutting off services, and they see this bill of $30,000 on hair and makeup, and some of these people can't even afford a meal. So public perception is everything when you're in politics. You got to worry about that. That's it for today, you guys. That's all I'm going to talk about it. What you guys put in the chat, let me know what you think. Kennard said he bought a few pairs of boy shirts and some Yeezy slide. Lexi says all these politicians think about is living a luxury, nothing but the best for them. Screw you, citizens. You know what? It's kind of sad because you have politicians that maybe they never had anything before. You got Brandon Johnson. He came from a I guess public school teacher, maybe charter school teacher salary. I'm assuming he was a principal at one time, but maybe he made $100,000 a year or above, probably mid, close to 200,000. I mean, but the stuff that they do, it doesn't even make sense. Now, we know Tiffany Henry, she probably ain't never had no money ever. She probably been on the scamming and scheming things for the longest. Lady Diva says every state is a scam, the tax-paying people. Oh yeah, they're scamming the tax-paying people. You're absolutely right. Kennard, the DJ, said he spent that money on his BB. That's it. That's it for today. Kennard. You guys tune in tomorrow. We're going to talk about, I think I got some more information about Tiffany, and I believe we're going to talk about Flint. So tune in tomorrow. And if something comes to light with this YSL case, I'll bring it to, we'll talk about that tomorrow. Okay. So I am sending all my good to you. I will talk to you tomorrow.